So my question would be, you say that there is a lot of legal fragmentation, so a lot of countries that have different rules on civil liability, and that there should be a general response of the European Union. Actually, I have two questions. So is there any competence of the European Union to take care of this in the first place? And my second question would be, are there already any initiatives of member states who are making national legislation on this topic?
Yes, I will try to answer to these questions. With regards to the indeed legal fragmentation, and then maybe the European Union stepping in to provide a harmonized legal framework. And with regards to the competence of the EU, it's not indeed, it's a issue. It's not extremely clear to me at this moment in time. So I will, yes, it's something that has to be indeed much more thoroughly explored. But from a perspective of member states some of them are indeed introducing ad hoc liability frameworks, or not necessarily liability frameworks, but it could be ad hoc compensation schemes in a way, which is not necessarily the same. For instance, I mentioned indeed the UK, but outside now the EU, but it's a good example. The UK has the Automated and Electric Vehicles Act, which was adopted in 2018, and it provides for a facilitated compensation of victims of automated vehicles, which were driving in automated mode. And it says, stricto sensu, that in the cases where the vehicle is driving in automated mode, the vehicle liability insurer is liable to compensate the victim. If it's not in the case, the vehicle is also insured. If the vehicle is not insured, then the owner will be liable, and there will be difficulties, again, of bringing a claim against the owner. There may be difficulties in bringing a claim against the owner. And I know that there are different other initiatives also in other countries. Germany has also initiated some initiatives on maybe amending civil liability law. In France currently there is no, I'm not aware of any initiatives on amending the current system, because they could fairly apply to autonomous vehicles. So yes, there are some initiatives, but they're a bit scattered. And do think that we need a European response to that, but not the one that is currently being proposed, at least at the Euro Committee of the European Parliament, which is a one-size-fits-all solution, where we would have a liability framework which will apply irrespectively to unmanned aircraft, which will apply to autonomous vehicles, the same liability regime, not taking into account the specificities of each sector. Obviously, the risks in each sector are different, and you can't just artificially say, well, we need one liability regime with certain rules which will apply to different kind of high-risk AI applications, such as autonomous vehicles, aircraft, etc.
Okay, and so this system of the UK that you mentioned,
yeah.
Could the European Union draw some inspiration from that?
Yes.
Would it be desirable to implement a likewise solution in the EU?
Yes, it's a possibility. So this it's really kind of the first piece of legislation that was adopted on autonomous vehicle in a very anticipatory way. It's interesting for several reasons. As I said, it facilitates certain claims by victims to get more easily compensated. However, there are certain shortcomings within this law, and one of the shortcomings is what would be the scope of this compensation mechanism. Do we apply it? Because in this Automated and Electric Vehicles Act, they mainly refer to highly or fully autonomous vehicles, but it doesn't seem to apply to partially autonomous vehicles. So then we also need to know what would be the scope of these liability compensation schemes. And also, as said before, we don't know how these vehicles will be deployed. You know that there's discussion on whether there's the evolutionary perspective on deployment or the revolutionary perspective. The evolutionary says that we will be gradually implementing level 3 vehicles, so partially autonomous vehicles, then level 4, and then level 5. And then you have another perspective saying that, well, because of the difficulties that we identified with level 3 vehicles, the uncertain human-machine interaction, it's better to deploy right away fully autonomous vehicles in that sense. So yes, the UK system is interesting, has some shortcomings, does not solve every issue, but could serve as indeed as an example on how we could try to deal this if we need at the European level a European response to this, through this harmonization of compensation for road traffic accidents involving autonomous vehicles.
Okay, thank you, Orian. Relating to the different levels, there has been a comment in the chat saying that I've seen some articles that say that level 5 autonomous driving will never become reality in open public roads due to legal liability issues. Do you have some thoughts on this comment?
I'm not sure, as we tried to show in the presentation, I mean, I'm not so sure that the liability hurdles in some cases are not that insurmountable. With level 5 vehicles, indeed, you just have a user on board, which is basically a passenger. You can't attribute, in systems which have a fault-based liability, you can't attribute liability to the user, except for having prevented certain software updates, etc. So yes, from my perspective, it's not necessarily true that it will never become a reality for legal liability reasons. Maybe for technical reasons, safety reasons, it won't become a reality. I don't know, but yeah, that's a good question. We'll have to look into it more.
Maybe Charlotte, do you want to add something?
So if I may, I'd like to add something to the question you raised in the first place. Well, because Orian and I, we said several times that our role is not, the role of lawyers is not an easy one, because we don't know yet what autonomous vehicles would be like, whether they will be on the roads at all for legal or other reasons. So it's a bit of a prospective work, but there are already tangible things going on, and these are tests. So we do have tests of more or less autonomous vehicles on open roads. And on this, we have legislation, more or less, either as hard law or as soft law, because there is some sort of a race actually between various countries within the EU, but also elsewhere. We know in the US they are very keen on testing vehicles on open roads. And at least in the EU, under UNECE under international treaties, Vienna and the Geneva Conventions, you are not allowed to have autonomous vehicles on the road. Then, for the sake of testing them, well, you need a certain level of legislation. There are questions whether it's at all compliant with international law to even test those autonomous vehicles. So what, for instance, member states try to do is they usually try to enact specific legislation with specific safeguards. And there you can see the emergence of what you could call regulatory sandboxing, of regulators and businesses coming together and trying to set up testing environments with exchange of information. And I'd like to refer to the work made by our colleague Ivo Emanuelov in the context of Concordat. So he wrote a deliverable partly related to this and to the questions, to the legal questions that it raises. So I'm hinting at this because this is very tangible, actually. Even the testing phase already raises a number of questions, and this is already happening. So that's why I wanted to mention this.
Thank you, Charlotte. In the meantime, there has been an intervention of Peggy in the chat, but you have already answered the question. And I see there are people typing. Okay, there's another question in the chat of Saturo. If you want to open your mic, or otherwise I will read it. The focus now is clearly on setting clear rules for testing of level 3-4 vehicles, as for example, the amendments of 2017 to amendment of the German Road Traffic Act. Do you think experience gained in such test sites could inform sufficiently future lawmaking, including vis-à-vis liability?
Maybe I can answer that.
Yeah, go
mainly
ahead.
On the work of Ivo Emanuelov, as I mentioned, we worked together, but it was the main, it was the main leader in this. Well, I have to admit, I don't know about the German amendments as such. I know more about the Belgium and the French ones, for instance. And well, I would say it really depends on the member states. They don't all have the same strategies. I have to say I'm very critical on the Belgium strategy, because the Belgium strategy is purely soft law based. So, well, there is an amendment at a royal decree, but it's extremely vague. So it's a very bad legal basis, and it doesn't provide for the lawmaker to be able to get information. So when you can find technical arrangements on how it should work in the field, who should do what for the testing, who should inform whom, who would be liable for what, then it's only soft law. So this raises a number of questions. Then you have the French way, which is, I'm French, so I dare criticize my country, but the French law is of course very administrative. So you first have a law, and then you have, I think you have an ordinance, and then you have a decree, and then you have another thing. So it's a cascade of text in order to set up a testing environment. I don't know whether it's better or not. It makes things very complicated, but at least the aim they have is to indeed have an exchange of information between businesses and public authorities, so to say, and therefore, indeed, maybe it helps gain experience to inform future lawmaking, which is one of the purposes of regulatory sandboxing. Well, I'm a bit in doubt whether I should use this term, because it's debated as a term, but this idea that you set up a dedicated regulatory environment in order to test, so that's the beneficial side from businesses, that they can test their technologies, and on the other hand, you have public authorities and maybe the lawmaker who can also gain information and knowledge from this testing. What also is interesting from this is that it already features some emerging roles. So, for instance, you see Orion and I, we both mentioned the emergence of maybe new roles as operators, backend server operator, or however you name it. And in the testing environments, you can see this, and there is an increased regulatory focus on those backend server operators, the one that is actually in an office and having 10 screens and supervising what's going on and acting upon an incident, for instance. So this already gives hints as for how the future could be like. But it's, of course, you can never completely anticipate what actual reality of autonomous vehicles will be like, but it gives hints.
Okay, thank you, Charlotte. In the meantime, there is another comment or suggestion in the chat saying that it probably comes down to whether consumers or car owners would feel comfortable with whatever the law would allow or not allow. I don't know if there are any other questions. It's the moment now to raise them. If not, I would like to thank Charlotte and Orion for their very enlightening explanations and presentation. Thank you for taking the time to present this topic in the CIF seminars. And as I mentioned at the beginning of this talk, the next talk will be on the 6th of April. On online tracking and anti-tracking evasion. There will be an abstract published on our website soon, and I will send out the invites as well. But Peggy wanted to say something. Trust is crucial, but first we need to change international law stipulating that a driver should always be fully in control and responsible for the behavior of a vehicle in traffic according to the Vienna Convention. Yeah, no problem, Peggy.
Maybe I can react on this again
Of course.
to advertise the work of Ivo Emanuelov, because this is also something he worked on. So both Vienna and Geneva Convention, they indeed require a driver behind the steering wheels. And one of them got amended in order to facilitate the deployment of autonomous vehicles. I'm not going into the details, but let's say that, so Ivo analyzed these amendments, and his conclusion was that actually it may end up being exactly the contrary of what it was intended to do, namely that it could make the life of autonomous vehicles deployers even more difficult than it's like with no amendment. So let's say it's a topic that is that's been discussed for a few years now. The problem being that you need to have an agreement with all, or at least a majority of signatories of the treaties, which is not an easy thing to do. So there are ups and downs. Sometimes there is a political interest in amending those conventions. Sometimes there's none. But it's a debate. So if you're interested, you can definitely reach out to Ivo Emanuelov. Maybe we'll let you read his deliverable in Concorda, which is partly dedicated to this.
And has he written a paper about this topic? Charlotte, I don't know if you know.
Sorry?
Has Ivo written or published a paper on this topic?
As far as I know, he hasn't. I pushed him towards doing this, but
yeah, maybe we should encourage him more.
Yeah, maybe you can push him as well. I think it would be of great worth.
Okay, thank you very much. So it's time to wrap things up here. But again, thank you to all listeners for participating. And thank you, Charlotte and Orion, for your talk, which was very interesting. So hope to see you next time, next month. Bye-bye, everyone.
Thank you, Sophie. Thank you, Jan Tobias. Thank you.